Good morning. My name is Mitch Panter. I'm an attorney with the law firm of Panther and Pedro. We represent people that are injured due to the negligence of others. I want to welcome you to Law Talk. Let me give you a little bit of a history of what Law Talk is all about. More than 30 years ago, my brother Brett and I became lawyers working together, and we opened up a TV show on public broadcasting called Law Talk. The goal was to educate people, to give you a little bit of an idea as to what the law is about. There are so many varied types of law, different kinds of law that can be done, criminal and civil and federal and state, and personal injury and medical malpractice and real estate, tax, immigration. So what we're going to do over these next few weeks is introduce you to several really good, qualified, competent attorneys that'll talk to you about what they do and how they do it. Again, the purpose is to educate you, to get you some information with regards to different areas of law, and to also have you contact these people when you have a problem or an issue. So today's guest is Steven Silverman. Steven, introduce yourself. Who are you and what do you do?
Well, I'm a local person. I've lived here almost all my life. I went to elementary, middle school, and high school here at Palmetto. And then I went to the University of Miami and got my undergraduate degree in Bachelor's of Business Administration. Then I went to law school at Emory in Atlanta, Georgia. And I've been practicing down here in the South Miami, Kendall, Pinecrest area ever since. So I've been doing this a long time. I'm a sole practitioner. I've been practicing in this area of estate planning and probate for most of my career. And I'm what's called Martindale-Hubbell rated. That's one of the top independent rating systems of attorneys nationally. And I've been the top rating AV for almost 25 years now.
That's wonderful.
Thank you. And I'm involved in our community. I'm a past president of the South Miami Kendall Chamber of Commerce, which is now Kendall South. I've been involved in different things. I'm a past board of directors member for the Financial Planners Association of Miami, and I'm presently on the board of directors of the Estate Planning Council of Greater Miami.
And also of equal importance for today's purposes, you are a member, a good member, a longstanding member of the Panther, and Pedro network. Let me just tell you a little bit about that. So about 12, 15 years ago, we decided that we wanted to be able to form a network. Panther, and Pedro does a lot of advertising, and we're very active in our community. And so one of the things that we wanted to do was we wanted to be the go-to lawyer. We wanted to be a type of lawyer that no matter what your needs were, you had access to good quality vetted attorneys that handle those needs. So one of the first things that we did was we set out to start meeting people, and we obviously had a great meeting with Steve and decided that he was a great, qualified, competent attorney that we could become part of our network. Steve, why and how did you become a member of the Panther, and Pedro network?
Well, I knew you guys a little bit in the past, and when you reached out, I was excited to have this opportunity to get involved with this group of attorneys. Most of the attorneys that I've met in this group are extremely high quality, excellent attorneys, and I was thrilled to have the honor to participate in this group.
And we're thrilled to have you as well. So let me give you a hint. The hint is called board certification. So whether you are an attorney or a doctor or a professional, there's a category called board certified. Myself, Brett Panter, David San Pedro, we are board certified attorneys, which means that we've gone that extra distance and we represent individuals with the category of board certification. So ask your doctor, ask your lawyer, are they board certified and are they competent and are they capable of doing the kind of services that you want? Steve's going to tell you in a few moments about his qualifications and the cases he handles. So let's jump right into it. Steve, what's your area of expertise?
Well, my office focuses primarily on estate planning and related areas such as probate, asset protection, prenuptial agreements, and other areas that relate to that. I specialize basically in helping clients plan their estates and how to avoid the potential problems that might occur during their lifetime or potentially for after their lifetime. We say we help our clients throughout lifetime and afterwards because a lot of the planning we do will affect them during their life, but also will affect them and their families after they've passed on. So people haven't kept up with their documents. We have a lot of clients or people that come in to see us that did an estate plan, they did a will. And I said, oh, I did a will 25 years ago. Well, that's great, but little Billy or Susie is no longer a child and now has their own children and you're a grandparent. And all of a sudden, what you put in the will for them 25 years ago really isn't appropriate at this point. So one of the things we focus on is updating clients' estate plans. It's a very common thing, like I said, that clients don't keep their estate plans current. And it's a normal human thing. You've done a will, you forget about it. And
Well,
you
let me
don't
let
keep
me
up.
let me interrupt you on that part. So we all think of estate planning and wills as old people things. We don't think of it as something that you should do in your child, not your childhood, but in your youth, when you're younger, when you're 30, when you're 40, when you're first getting married, when you're first having children. When should somebody come and speak to you?
Actually, that's one of the initial times they should be doing it. It's so often we have people that come in, and the reason they contact us is their wife is pregnant or they've just had the child, and all of a sudden they realize, wait a second, I'm responsible for this other life, and I need to protect them in case something happens to me. If I'm not around, first off, who's going to raise our child? We need to think about this. And to me, the most frustrating thing is when I have someone come in and I say, who's going to do this? And they name someone. And then I say, have you discussed this with them? And they go, no. And I said, well, did you ever think that possibly they may not want to be raising your child? So there are a lot of things that people just assume will happen. And so we go through all that to cover all those issues with the clients because most of them haven't thought those out.
And I think you thought of it perfectly and you said it great, but let me just ask the pointed question. Why? Why do you do this kind of work?
Why do I do it? I get a lot of satisfaction out of doing this area of law. I practiced in many areas of law before, and I just didn't get the enjoyment and fulfillment of doing it. Whereas here, I know I'm helping people. I know either I'm avoiding a problem for them or solving a problem, and I know that they can go to bed at night having one thing checked off their list and relax and not worry what's going to happen to my child or my spouse or my parents or whoever they want to provide for, because we've taken care of that for them.
So somebody comes into your office. I presume you speak to them first, you make an appointment. What do you tell them to bring with them? What's that first initial interview or discussion all about?
Well, we approach it a little different. The traditional thing is you may have someone make an appointment and then they come in and start talking to you. We don't think that's the best way to do it. In our experience, the best way to do this is that we have like a welcoming package. And we found that clients really like this. We give you a letter with it that says, this is how we're going to practice and do your estate plan. We explain to you, you'll be dealing with me exclusively and other things, how we'll meet, all the logistics of it. And then we give them the 3 most common estate plan options that most of our clients pick. But the key is we send them 2 questionnaires. One is basic contact information and about 2 pages on finance. We don't need to know all the details, but big picture view. The second questionnaire is what we call issues and values. And this is why we think our clients come in much better prepared and able to approach this issue. We mention the different things that people have traditionally had problems with in planning their estate. For example, do you have a problem with a son-in-law or daughter-in-law that you don't trust them? Do you have a child that might be autistic or somebody that has special needs? Or there are a lot of different issues like that we, in the questionnaire, we say, is this a high concern, some concern, or no concern? And I can't tell you how many times clients have come in when I look at their questionnaire and they say, I was thinking about this, but I couldn't focus as to what exactly the issue was. And reading this helped me. Now, the key is I could have someone come in my office and do this, but they're not going to have all the information. They're not getting a chance to think about it. If they do this, when they send this back to us, then we send them a link to my calendar. They can go online and pick any date or time that I'm available that meets their time, and we schedule that meeting then. This way, they're ready for the meeting. They know what issues they want to address with us, and then we can do a great job for them in accomplishing their goals.
And I think you said something that I want to hit on. It's really important. It's a 2-part thing. One is you kept saying we, and we do the same thing at Panther, and Pedro. It's a team approach. But more importantly, you said they call you. And we're big on that. The bigger law firms, bigger is not always better is a lot of our mantra, what we're going now. When you have bigger, it's not necessarily better because you don't get to speak to the person that you want to speak to. And it sounds to me that you've got that Panther, San Pedro approach of family. So how does your family work to help people and their family?
Well, just as an example, like you said, it's the contact with the principal person you're going to be dealing with as opposed to someone else. We all know that if you tell someone something and then they tell someone something and then they tell someone something, the third person isn't going to exactly hear everything the same. When I go direct with them, I know what they're saying and their concerns, and we can discuss it. And I take notes and we make sure we cover that. I have staff that work with me. For example, one of our areas we do is probate. And I have a probate paralegal that's been with me for 14 or 15 years. And she knows what she's doing. A lot of times we joke she knows it better than me. And so she does most of their stuff in probate. I obviously supervise and I see what's going on.
Let me stop you now. What does probate mean in case people don't know what that means?
Well, probate is part of estate planning. It's sort of the result at the end that could happen. If you die in Florida, you have what's called a probate administration, which is a fancy word for handling your estate, gathering the assets, determining if there's any creditors, paying those bills, and distributing the assets the way you intend it to go, whether it's to family, to charity, or whatever. If you have no will or you have just a will, then all your assets, other than certain selected ones like life insurance or stuff, go through probate, which means a court gets involved in your estate planning after you're dead. They're going to take your will, if you have one, and say, you gave this, this, and this to this person, and this, and this to that person. And they're going to enter orders that will pay your creditors, distribute the assets. It's a great system, but it's slow. It costs a lot of money. It takes way more effort than it did when I first started practicing down here. There were only 3 judges in probate division. Now, it's been over 30 years. The population's like tripled, and we finally went up a year or 2 ago to our 5th judge. We should have like 8 or 9 judges just dealing with this because there's so much demand for it. But we work with the system we have. However, we have a lot of ways that we can avoid probate, either totally or almost exclusively, with proper estate planning, so people don't have to put their family or friends through the long wait, paying the attorney's fees and the other fees that are involved in this. And that's involving proper estate planning. A lot of times it involves a living or a revocable trust. There's other ways of structuring your assets so that we don't have to have the court involved.
Let me break that down in 2 parts then, because I want to make sure we all understand it and are clear with that. One is to probate or not to probate, and the other is to will or not to will. So when would you, let's start with the easier one, a will. What's a will? How does it work? Does everybody have one? Is it an easy thing? How can you help us with that?
Well, a will is a written document. It has to be witnessed and notarized in the state of Florida to be admitted into court without witnesses coming in to testify. So they usually are prepared properly in writing with witnesses and a notary.
Let me stop you. Is that something you do?
We do that, right?
Okay. Is that a complicated thing? Is it an easy thing?
A will can be very simple or it can be very complicated. There's no, you can go online and for a few dollars get a basic 2 or 3 page will. For some people, that's great, but most people, that isn't what they want. They need to understand, I have kids or I have this or that, and they need to have some guidance. We don't actually do wills versus trusts. It's a will versus a will and a trust combination.
What's a trust? You're using that word.
A trust is a fancy word for sort of something that you put your assets in and it operates them. It's sort of like a suitcase or a pocketbook. You can put your assets in there and then they're governed by that trust agreement. A trust is a written document like a will, has to be witnessed and notarized also. But the purpose of that is to avoid having the court determine who gets your assets. In the trust, you say how that's going to be done. And if you've titled those assets in the name of the trust, whether it's real estate by doing a deed or retitling a bank account or a securities account, whatever it is, if you put the asset in the name of the trust, it will avoid probate very often.
Let me ask you a question. So my mother-in-law has an account at one of the brokerage houses, and they talk about putting that money in a trust. Should they rely upon the broker to do that? Or is that something they should probably come to you, a qualified, competent attorney that specializes in that, to make sure it's done correctly?
It's probably going to be both of us working together. Okay, because you don't want to go just to the institution, because a lot of times you're going to be dealing with a lower level clerk or clerical person who doesn't understand anything about this. So we can help you find out, what you need to do to retitle that bank account or
so the title
account.
is important.
Yes, the title is extremely important.
What does that mean?
Okay, so if I have a bank account in the name of Brett Panther, okay, you own it. It has your own social security number attached to that with the bank or securities firm, and that's how it's reported. A trust, if it's properly set up, could say this is Brett Panter, trustee of the Brett Panter Trust. Now, you still would use your social security number, so it doesn't have any separate tax reporting or tax increase. But when you die, that trust is a separate entity in effect at that point, and you do not need to have the assets put into the trust. They're already there, so they don't have to go through the court system. The advantage, you could have those assets available to your beneficiaries in 2, 3, 4 weeks, whereas if you went through the court, it could take 8 months, a year, possibly even longer.
How does this work? We've got death on the one hand. How about disability? Somebody becomes incapable or incompetent. How does it work under those circumstances?
Well, there's a few things you need to have in that case. And this is part of most of our plans, is you need your 3 medical documents, and you also need a financial power of attorney. The 3 medical documents are a living will, a healthcare power of attorney, and what's called the HIPAA authorization form.
Well, let me stop you there. What I want to do, because these are really important things, what are each of those? Why do you want them? And how do you do that?
Okay, so let's talk about the living will. Most people have heard of a living will due to the Schiavo case, which was in Florida about 20 years ago. And the living will is where the person who's signing the will says, if I have a medical condition where 2 doctors have certified I am not going to recover, this is a terminal condition, and usually it's a circumstance where there is no brain activity involved, then at that point, what you are saying in the document is, I don't want to be kept artificially sustained on the machines. Let me die naturally. Let me go off the machines and just live.
You're making this decision while you're capable and competent to make that decision. You get to decide what happens when you can't decide anymore.
Correct. You're making that decision now, when you're not under any pressure or anybody's doing it. And so it's a good decision that you've thought about and provided, some reason to it.
And is this a form that they could call you and for, circumstance, make an appointment with you and have you do, your office do?
We would do this as part of our standard representation of all of our clients. All of our clients get all 3 medical documents because we think it's so important. And most often they do too. The second document is the healthcare power of attorney. Now, this can be a serious life, ending circumstance, but usually it's not. Usually you're in a car accident or you're in a coma and you can't make a medical decision, but it could be something that needs to be done that's not life extending or prolonged. Simply, you need a blood transfusion or you need authority for the doctor to do an operation. Well, if you're unconscious and not capable of making the decision, who did you want to make that decision for you? Because you just don't want anybody. It might be that you have 3 kids. One of them is a nurse. That's the one you want to make the decision, not the one that may be the banker or the artist or something. So you're going to select the order of decision making for your people when you can't make it yourself.
Can you have more than one?
You can have alternates, 2, 3, 4. I would recommend you don't go too many, because then it gets a little complex and then you start raising family issues up and stuff like that. But the idea is your wishes are what we want to have carried out, not what somebody else thinks you want. It's what you want. And the last form actually may be almost the most important, which is the HIPAA authorization form. We all have these things. You go to the doctor's office and you sign a paper saying you were there, and you have no idea why are you doing this. This is so that they are authorized to release your medical records to the appropriate person. So you're going to say, yes, I want my spouse and I want my kids to be able to talk to the doctor, because otherwise the doctors and the hospitals aren't supposed to communicate anything about your medical condition to anyone. It's private information. So this lets them know who you wanted to be able to have this information.
So you got these 3 documents. What do you do with them?
Well, we always recommend that you, number one, have discussed with the people you've named and let them know that these documents exist. Now, we give all of our clients not only the originals of all these documents, but we give them on a flash drive memory stick all of their signed documents. So if they want to send to their sister or their son or whoever these medical documents, they just email them to them or print them out and hand it to them. But they have the ability to distribute these to whoever they want. And it's important because, as we tell people, if you've done a document but no one knows that you've done it,
Right.
It doesn't help much. It's like people say, I want to put in my will that I want to be cremated or I want to be buried. And I say, that's not the right place to do it, because we may not look at that will for weeks. And if you wanted to have one or the other, it's going to be too late to change. So you need to talk to the people in your estate plan.
Your lawyer.
Well, not just your lawyer, your family members, whoever are closest to you, so they know what your preferences are.
If you have a primary physician.
Primary physician, you should give them a copy of those
spouse,
records.
children,
Spouse,
those
children.
people that are going to be involved with handling that situation.
Correct.
Okay.
Exactly.
So we got that sort of stuff. A will. What's a will? How does it work? Who gets one? Why?
Okay. A will is a basic part of any estate plan. It says in writing, again, witnessed, notarized, what you want done with your assets. Now, if you have a will and a trust, the will is going to say everything I have, follow the terms of my trust dated such and such. If you just have the will alone, the will is going to say, who do you want to be the guardian of your children? Who do you want to receive this asset or that asset? And if you want to set stuff up, let's say trust after death to be created for, let's say, children or other things, it distributes your assets, basically.
So you die in the state of Florida, you don't have a will, what happens?
The state of Florida has sort of a will made up for you. In other words, under Florida law, they've said if you die without a will, here's the order of priority of your assets. It's going to be obviously your spouse and then children. And then after that, it goes to grandchildren and parents, and it goes what's called the family tree. It goes down the family tree and up the family tree, depending on what level of relationship people have to you. And, if that's fine and people just want to let the state decide who gets all those assets they've worked for, that's one way of doing it. But most people don't want the state to decide how their assets are going to be distributed. They want to make that decision themselves.
So what happens if you pass away and you don't have mom and dad and you don't have a wife and you don't have children? Who gets it?
Well, it could go to brothers and sisters, or if there are no brothers and sisters, it could go to cousins, or it could go to aunts. It could go any variety of ways, depending on your family that's alive.
And if you don't,
it's set out in the law. It's exactly set out. There's certain relationships that, in order of priority and who's related and who's closer and things like that.
So we've talked about who you want to include. What happens if you want to exclude somebody?
Yes,
that cousin in the third degree, or the brother or the mother or the aunt, somebody that
very often this happens. And it's very important because people, when they are left out, oftentimes will not just accept it and will decide that they wish to challenge. So the way you want to let out, disinherit someone, as it's called, is to specifically state that you are disinheriting them. If you don't, they have an argument to be made that says, oh, they meant to include me, they forgot. Okay. And the worst thing that some people see, because it's, I think, been in movies, is we're going to leave them $1. And that's about the worst possible thing you could do, because you've now made them a beneficiary of your estate, the same as any other beneficiary. And they have all the rights of any beneficiary to get records from the estate, to see the financial transactions, to go into court and have standing to object to what's being done. Whereas if they're not mentioned and they are deliberately disinherited specifically, they don't have that standing to go into court. So in fact, I just saw, I'm part of a group of professionals that do probate and guardianship in the Miami-Dade County. We have our own little list group that's on the internet. And somebody was just mentioning recently about how someone had done that. They left somebody in for $1, and that person's tied up that estate for years now. So you don't want to do that. That's why you need to have someone advise you on what the right way to disinherit versus making a mess.
So we see online nowadays, there's all of these, you could howtomakeawill.coms. Good, bad, not the right thing to do.
I think they're very appropriate for somebody that has very little assets and doesn't have the time, doesn't have, for example, like children. If, for example, you're single, you have no children, you have a very basic, you don't even own real estate. Somebody like that is a perfect person for an online will, because they don't really have that much and it's not that complicated. But once you start adding all the complexities of our lives today, you have children, you may have grandparents or parents that you're providing for. You may have a charity you want to help out, or a church or something you're involved in. There's so many things that, you've got to decide what do you want to prioritize in your life and afterwards. And so if you have very little, you could probably get away with it. But if you have a family, if you have assets, if you've saved stuff up over your lifetime, you really need to do it right, because you're going to be gone, but you're going to leave this mess with your family. And why would you want to do that?
So let's talk turkey money two ways. Number one, what do you charge? How much does it cost to do the various things that you do? And then second, at what point is there a dollar number that you have to do certain things? Because if you have 1 million, 2 million, 6 million, that range. So let's do that one first, and then we can ask about what your charges are.
So what we do is we handle estate planning on a flat fee basis. It's not an hourly charge. We do this intentionally because, frankly, most people, when they meet with an attorney, if they're not familiar with dealing with attorneys, are worried they're going to be charged for every time the attorney gets involved or touches the file or makes a phone call. Flat fees mean I can, once I've had that initial meeting with the client, give them a pretty good estimate of what their cost is going to be. So if, for example, we have the 3 most common estate plan options, and they can all be modified, of course. If people have more complexities or it's more simple, we can adjust it. But basically, there's one package, which is a will, the 3 medical documents, and the financial power of attorney. And that ranges anywhere from $1,500 to $3,000 on the low end, depending on what they want. Then if they move up to the middle level package, which is what we call our advanced package, it's a will and the trust combination with all of the previous documents before. And that runs anywhere between $3,000 to $6,000, depending on what they want, how many people, and the complexities of what they're doing. And then we have our signature plan, which is the advanced one. These generally are involving people that have potential tax issues in their estate plan. So generally, the advanced ones are people that are going to be over $10 million in assets, because there are a lot of issues that come up with those, and some of them involve advanced estate planning. And so it's hard. Those are more open-ended because we don't know how complex they're going to be. Most people fit into the middle category generally that we work with. If you own a house in Pinecrest, South Miami, and the Gables and Kendall, you're probably got a house that's worth at least $500,000 nowadays. And maybe a lot more. And so once you're starting to get to that number, you probably do want to have some type of advanced financial planning. The middle level seems to be what most people want because they have other assets too. It's not just your house. You may have life insurance, retirement accounts, savings, things like that. And so the good thing is you have a lot of assets. The bad thing is you have to do planning for those assets that you work so hard for.
But your planning changes. I know that, for instance, when you first start out, I'm a young professional and I'm making a lot of money and I get married. Now, all of a sudden I have a child. Now, all of a sudden I have college funds. Now I have parents to take care of. How do you account for those different stages in life so that your needs are going to change, your rules are going to change? How do I address that?
The living trust is what enables you to do that. Everything in the living or revocable trust is totally flexible and modifiable. You can always change it at any point. So what happens is, just as you're saying, as people's lives change and they get older, different things happen, whether they have grandkids or kids or
Parents to take care of.
Or the sandwich generation that have everything. They have both. You can always modify what we do. Almost everything other than certain advanced planning, like your revocable trusts, can always be modified or changed while you're alive. And it's very normal that either due to a change in your circumstances or a change in tax laws, clients come back to see us every 3 to 5 years to look at and see if they need to make changes or not. Generally, we will not charge an existing client when they come back to meet with us for the initial meeting, that 3 to 5 year period, because a lot of times it's a very simple process and we just may need to make a minor change or something. Or if there's a real lot of work, then, we do that. It just depends on what the client's needs are. But that's generally a common time frame, 3 to 5 years to look at stuff. It just depends on the people.
When do I start? When's the first time you want to see me?
As soon as you call us or send us, reach our internet page, and we have a link there that can take you through the whole process of seeing stuff. We send you that welcoming package, and as soon as you finish that, we'd love to see you.
What does the welcoming package do? Does it help me to understand
what's
happening?
Right. Those were the things I explained before. The letter welcoming them, explaining how they operate, that they meet with me, the options of the most common choices, and then the questionnaires. That's the welcoming package. Once we have
Is there a charge for the welcoming package?
No charge at all. And if they fill that out and return it to us, there's no charge for the initial meeting.
Big question. How do I get the welcome package?
You can call us at my office, 305-666-6111, or go to our webpage, stevensilverman.com. We've got 13 or 14 videos that explain estate planning for you there. For example, each of the medical documents has its own short video for it. We have all sorts of information, and there's plenty of articles, frequently asked questions that people have on the website they can go look at. It's a very helpful resource, and then we go and we help you, and then it's one-on-one. We spend as long as we need to get your estate plan the way you want and to make it done so that you're comfortable with what decisions you've made.
One more time, website, phone number, how do I contact you?
Website, stevensilverman.com. If you want to email, you can do info@stevensilverman.com. And if you want to call us, my phone number is 305-666-6111.
All right. That's going to conclude it for today. We thank you, Mr. Silverman. Steven, thank you very much for coming. Again, if you have any questions, scroll over here, stevensilverman.com. This is Mitch Panter with the law firm of Panther, Panter, and Pedro. As always, you can go onto our website at pantherlaw.com. Ask to speak to me, myself, Mitch Panter. We're happy to talk to you at any point in time. Our goal is to be the go-to law firm. Any questions you have, any issues you need, we want to be able to help you. So at any point in time, if you have a question about any area of law, please feel free to contact us. We're going to be bringing you a lot of different lawyers with a lot of different topics in the upcoming weeks. We hope you learn. We hope you contact Mr. Silverman and learn something from him, and have a great day.